Good morning, all of you. And this is a topic which has become something like a new mission for me. Um, we, you know that I have been working on the field of cyber law for quite some time, and then started working on the data protection. And ultimately, in 2018, we started the FDPPI, which was a major step forward towards working for the data protection community. And now, after 4 years of FDPPI, I feel that there is a need for some renewed effort, which I have now tried to codify under this Federation of Data Protection Consultants in India. I will try to explain my vision on this. I'm open to making further improvements on this and see that all the suggestions, if any, are incorporated, because we would like this to be helpful to the entire community, both the industry as well as the individuals in developing the area of data protection. Now, towards this, we can just recollect what is the emerging data protection scenario in India. Now, after several years of deliberation, um, maybe starting from 2005 onwards and 2008, 2006, when there was a bill presented in the parliament for personal data protection, which was of course forgotten for quite some time, until 2017-18, when the Supreme Court revived the debate and we came up with the Sri Krishna Committee, PDPB 2018-2019, then the JPC revising it to DPA 2021. With all those developments, it appears that we are now coming to some kind of seeing the light at the end of the tunnel with the DPB 2022, as it is presented now. It may become Digital Personal Data Protection Act 2023 by around March 2023. It appears government has very serious intentions of bringing in the law. The way they brought in the telecom bill, and now I think they have already incorporated the public comments and come up with a revised telecom bill. I think yesterday or day before yesterday news was there. Even I have not gone through that fully. Maybe we'll go through it in a day or two. The government has also announced the introduction of the Digital India Act, which will be a replacement of the Information Technology Act. And going by these two developments concurrently with the DPDP bill, it appears that government is really serious. This will not be like the earlier occasions where things will get deferred. And all the professionals and the companies are actually wanting some certainty in this. Uncertainty is what makes it difficult for us. But now I think that may not be there. Welcome, Rajesh. Yeah. So with this, Mr. Ramesh, can you send the invite to Mr. Rajesh privately?
I'll do that. I'll do that.
Okay. So now with this new act, what will happen is companies will have to immediately go into a huddle. Their boards should have met by this time if they were progressive, or they will meet before the end of December, whatever is the quarterly meeting. Some of them may be having the year end and planning for the next calendar year. At the board level, by this time, there should have been a very serious meeting on what will be the things to do for the company if this act comes in. I've always been highlighting that it is not a question of if this act comes in, because we already have Information Technology Act, which is there since 2000, and until that is abolished, there is a data protection requirement under Section 43 capital A of Information Technology Act, which every company should have been in compliance even now. So this new act is only an advancement of that. It is not something which is coming from heaven. Okay, just like GDPR was a conversion of the earlier data protection directives, this data protection bill will be a conversion of the section 43 capital A of Information Technology Act, under which in 2011 we had the reasonable security guidelines. So companies should recognize this and start working on how they migrate into this new data protection scenario. The first thing they will have to perhaps do is to recognize their status in terms of the act. Basically, we are looking at recognizing whether they will be considered as significant data fiduciaries, for which the government has to come up with the definition of significant data fiduciaries, because now they are saying that apart from the volume and sensitivity of the information, there will be other criteria under which an organization will be considered as a significant data fiduciary. So the board has to first look at the question, am I a significant data fiduciary? Because a significant data fiduciary will be required to have a data protection officer, required to appoint a data auditor, and will be required to conduct the DPIA. And essentially, they will have to do everything under the compliance by design kind of an idea. Earlier, it was a privacy by design policy, but now at least internally, they must have the policy in place. Whether they submit it or not is a different question. But this is an exercise which has to start. They have to also look at either opening up new business opportunities as consent managers, or how do they interact with consent managers. And then the deemed consent status, they have to review. They have to look at cross-border transfers. They have to look at parental consents for minors, nomination requirements. How do we bring in the systems for that? Then identify data protection officers for their organization where it is required, identify data auditors. All these things are required, and they will have to actually issue new consent notices to all the present data principals with whom they are dealing with, which itself is a massive work. And they have to also have a system of how to deal with a situation where they send out the consent reconsent requests to people, and they don't get more than 10% response. Then what do you do with the 90%? Are you going to remove them from the business data and then stop processing them, which will hurt 90% of the business? So these are all issues what needs to be done to increase this response from 10% to higher and higher, and kind of a thing, so that the rejections of data will be very minimal. Maybe some discussions may be required with the data protection board regarding how to deal with the legacy customers who do not respond to the new consent request. Whether the government will say that if you have sent a proper request for consent, can it be, can non-reply be considered as a deemed consent, is something which needs to be looked at. So then maintaining the accuracy of the data, Information Technology Act said 1 year you have to renew. So what will you do in the personal data protection area? Then all the organizations need to work on the grievance redressal system. So these are all the requirements which are developing in the corporate scenario. If there is a DPO already, he has to actually chart out a program for all these compliance requirements. Say from the company side, let us not worry about some privacy activists complaining about government having too much of powers. We are not happy with this thing. We want the bill to be withdrawn or something like that. There is one school of thought which will be working on that. As far as we are concerned as companies, we are not bothered about worrying too much about that. Or if somebody says, privacy of the individual is not fully protected, like GDPR, there is no right to forget kind of a thing. These debates, you please leave it aside. Let we as corporate sector, business oriented organizations look at the compliance requirements. If in the compliance requirements we have got some issues, let us take it to the ministry. I am sure they will be responding it promptly. So if nomination is a problem, if grievance redressal system is a problem, if deemed consent is a problem, if legacy information, data principles is a problem, that is something which we have to take it to the ministry. We will not worry about the data localization or other issues which are things which can be handled by others. Now, along with this, if you look at yesterday and today, the Minister for MOS for IT, Rajiv Chandrasekhar, has made an announcement that within a week or so, they will be coming up with the new draft for the replacement of ITA 2000. If it happens, that also will open out a brand new area of discussion. Of course, already ITA 2000 compliance was there, and now we have to see what changes are going to happen. Now, in this kind of a thing, there will be concerns that we need thousands of perhaps data protection consultants just to meet the requirements of DPP bill, and of course the emerging ITA 2000 replacement. And the concern is, where will these persons come from, and whether an organization can locate such consultants at the right cost. Everybody cannot afford a DPO at several lakhs of rupees salary per month, which they deserve in big companies. But not all companies can afford that. Whether there will be shared services or services which will be available from newcomers who may not be charging that several lakhs fees or something like that, is something which needs to be worked on, or it will be the concern. Now, what FDPPA proposes or had proposed earlier to do, and how it will continue, we need a brief mention. Of course, we have started our work on creating necessary skills in people with an appropriate certification program, and obviously that has to be now say upgraded. So you can look out for a certified data governance and data auditor kind of programs. What exactly it will be called, we will see, but it will be a combination of what we did earlier, that is the Indian law, global laws, and data protection skills, and maybe we will add technology aspects as well as these aspects. Maybe it will also undergo some iterations over a period of time, but we are going to do that. So we will be having this certification as one of the activities of FDPPA, and it will be upgraded. And month by month, if the government comes up with new regulations, our certification programs will be upgraded for what comes at least 1 or 2 days before we start a program. Like today, I am talking of the new data protection law coming as a replacement of the ITA 2000. We are to that extent very, very fleet-footed. We will incorporate the dynamic changes which will happen. So that will happen. Second, we had introduced the framework called fdpc, Personal Data Protection Standard of India, which will be updated as may be required, basically to enable setting up of compliance by design. Now, earlier we used to talk of privacy by design, security by design. Now, my focus has been compliance by design. So let us see what the government says. We will try to comply with it. So that will require a data protection compliance management system to be set up in an organization, which is slightly different from the ISMS and PIMS. And it may be possible that this DPCMS may consist of two parts, one for personal data protection compliance and another for non-personal data protection compliance. So within that, the system will have to be developed. And we will try to work on the upgradation of our current PDPSI systems, which we had already updated to DPCSI. We will try to further refine it as required. Then, as and when the policies and procedures need to be introduced, we will try to develop our own operational guidelines and, of course, try to interpret what the government may come up. If the act goes through in its present form, people are counting and saying there are 18 places where it says as may be prescribed. In fact, there may be not only 18, there will be perhaps 100 notifications which will come in the next 1 year from the Data Protection Board. We should be ready for that. So everything may require interpretation, may require dialogue with the Data Protection Board. So that we will continue to do. We will also update our data trust score system, which we already had. Now the data trust score may not be mandatory, or we do not know what will happen in the rules. But even if it is not mandatory, we as an organization would recommend auditors to adopt a kind of data trust score system so that there is a clear indication of the maturity level of the compliance of data protection requirements. That will continue to do. Additionally, we will be undertaking our own training programs, and through affiliate training partners, we will try to have a massive infrastructure for training across India so that knowledge should not be in any way curtailed. We will spread the knowledge to the extent possible, thanks to this mode of, say, virtual training. Now, I think it is easy to reach out to every other place. And we will also operationalize the online data dispute mediation platform, which we started earlier, but there was not many responses for that. We created a test bed, and we were ready to actually start a mediation. If you, even now, if you want a mediation from next week, I am ready to set up the system for that, provided we have a mediator, we have a client who wants that kind of a service, because that platform has been on pilot stage for a long time. And that will have to be upgraded, because you know now that in every law, even in the intermediary guidelines under Information Technology Act, the grievance appellate tribunal under the intermediary regulations, government is insisting that online dispute resolution mechanism is almost mandatory. So here also it will be necessary in data disputes. So we already have that, and we will try to upgrade it further. We feel that is a commitment to many of our FDPPI members who are lawyers and who are arbitrators and mediators, and they need to actually monetize their capabilities, and that will be as the mediators and arbitrators on this platform. So we would like to work on that. Now, with all these things in the background, which FDPPI will be doing and continuing to do, we are now thinking of one new kind of an activity to set up or encourage setting up of a federation of data protection consultants. And that is what I would like to share with you. Because people are asking me many times, you already have an FDPPI, what is the reason why you are going for something else which looks somewhat similar? So I have the need to explain my vision on this fdpc, that is the foundation of data protection consultants. Now, the basic vision is that I want all the data protection professionals, which today in FDPPI, we were limiting ourselves to privacy professionals. And because we were giving our certification programs, many people thought that FDPPI is only for FDPPI certified persons, and rest of the people who are certified by, say, CIPP or DSCI were perhaps looking at FDPPI as a different organization, and they were having their own hesitations in involving themselves fully with the FDPPI as an organization. Now, I am trying to break that barrier. because we are trying to expand FDPC into a platform which should be open to not only the privacy professionals who are presently under the umbrella of FDPPI or under the umbrella of DSCI or under the umbrella of CIPP, but also to information security professionals who are presently working on, say, ISO 27001 audits, working on, say, PCI DSS audit, maybe SOC audit. So maybe even COBIT, I don't know. So these are all persons who are providing their professional services towards the betterment of information security and data security overall. I want all of them to recognize that there is a sort of a common goal for all of us, because all of us want to actually protect data. Some people may try to protect only personal data. Some people may try to protect non-personal data. So they may call themselves as cyber security professionals, information security professionals. Some people may say, I will only look at GDPR compliance. Some people may say, I will look at Indian data. Somebody may say CCPA. So these are all the smaller factions within the overall community. I want all these people to forget these factional divisions and then come together into the larger community of data protection professionals. In fact, we must be able to show a combined strength in such a way that future policies affecting this kind of activities, we should be the voice to be heard by the government. And until we reach that stage, I think my mission will remain incomplete. So that is one aspect. Now, having decided to bring everybody together, then people will next ask, what is in it for me? So I have tried to envision two major benefits out of this congregation. One is, whoever is not an employee of an organization, but is trying to be an entrepreneur, a private consultant, who can be tomorrow's data auditor. Data auditors are going to be such consultants, or there could be individual implementation consultants. Now, I want all of them to be able to share their expertise with the clients who require similar exercise through this platform. So this platform has to work like a sort of a data protection service exchange, so that I have certain services, certain skills. If you need that services, this is the platform. You put in your inquiry. I will see if I have the matching inquiries, and then we will try to work together. That is the kind of benefit I want to give to the individual people who are in the consultancy area. Now, some of these consultants may not be individuals. They may be small firms where 5-6 people are there together. We don't mind if that congregation of a few people also join here, and ultimately all of us have the same kind of an object, that we need to serve this particular community. And at the same time, being a platform, on the other side, we would like to provide service to organizations who are looking for such service, more appropriately the SMEs and MSMEs, who may try to get the best offer from an available consultant, and they always are at the receiving end when it comes to getting the service from a qualified person. Now, this platform is open to the entire community of professionals. Within this, there would be people who are FDPPI certified consultants. There will be GDPR consultants who may be working under ISO 27701. There could be HIPAA consultants. There would be ISO 27001 consultants and others. We would like every one of them to come together. Please, for a moment, don't think that this is something which only Naavi is trying to do, FDPPI is trying to do. There will be certain, say, favoritism to FDPPI people or something like that. We would like to ensure that this is a platform in which, if an FDPPI certified consultant has got better credentials, he will get the better of the business. But otherwise, we would not, as a platform, try to actually bring in any biases into the system. We will try our best to ensure that this commitment is maintained. All of you will understand that it is not easy to maintain this kind of a commitment, but if I cannot meet that commitment, I don't think anybody else in India will ever be able to meet that kind of a commitment. I would like to say that say this platform will be something like the Uber of data protection consultancy. Of course, now the Uber concept also has been very much corrupted. I have not been happy with the way law has treated the Ubers and Olas as taxi operators. Actually, they are information data aggregators, and the taxi operators were the operators. Unfortunately, the government got some thought that they are losing the revenue because Uber is trying to aggregate even private car owners into this or something like that. They actually, in fact, in Karnataka, they changed the law itself in the RTO saying that Uber is also a taxi operator. Even today, I think that Ubers and Olas did not contest their court case properly. They should have tried to be only aggregators and not the operators. In fact, today, when you ask, say, Zomato, now Zomato may have contract with various food stores, and the contracts as far as the food related laws are concerned will have to be done by the particular hotel, not by Zomato. Amazon has got so many products, they are not exposed to the legal compliance of all those product areas. They are the aggregators. Likewise, Uber also should have done it, but they did not do it. Worldwide, of course, people who are jealous of the development of Uber ensured that they were all called taxi operators. And I am not looking at that kind of a concept. Here, I want FDPC to be recognized as an intermediary under the Information Technology Act and as an service aggregator and nothing beyond that. We are trying to ensure that our contracts are built on such kind of considerations. So this is something which you can keep in the back of your mind. Now, the consultants themselves, we are likely to divide them into some, at least a two column matrix. One will be based on their ability to execute contracts. For example, we may say class 1 consultants, they will be able to execute contracts of value up to 1 lakh, class 2 up to 5 lakhs, class 3 up more than 5 lakhs, something like that, so that we will be able to assign the contracts based on the class. We may not, of course, if a big contractor, class 3 contractor wants to take a class 1 business, that is open to him. But at least while recognizing their strengths, we would like to have some classification like this. And actually, new people may start as class 1 and then be upgraded over a period of time based on the experience. Whereas persons, consultants who have established credentials, they may directly be considered as a higher grade. So something like that we are thinking of organizing as far as the particular classification is concerned. Then we are working on a backup support system, which loosely you can call as underwriting. The idea of this support system is that when a small contractor is working, there may be situations where he may suddenly require the assistance of somebody else, or he may be failing in a particular execution. So in such cases, what I feel is that some of the bigger players will have to actually provide backup contingency service. Just like in the case of investments, we have the underwriters. If investors do not come in for an IPO, underwriters will take those contracts, something like that. So we are working on a backup system in which perhaps the details will be worked out so that for providing that underwriting say commitment as a contingent guarantee, they should get some reward, and they should have the capability of coming in as and when required. This will increase the reliability of the service. Again, here, I am not saying that this consultants, this underwriting will be provided by FDPPA or even FDPC. Perhaps FDPC will remain as a platform, but we will have people who have agreed to be such underwriters will jump in when it is required, so that legally we will be isolating the FDPC from the consequences of taking over the business directly. They will remain as the intermediary only. Now, for the purpose of running this empanelment, we have tried to think of some kind of a process by which there will be a registrar who will take care of the responsibilities until, first of all, the scoping will have to be properly structured. So the registrar will first get an inquiry on the platform. When an inquiry is placed, he will finalize the scoping document. Then he will broadcast the scoping document to all the consultants on his network, and maybe some of them will offer to undertake this contract. We hope that there will be enough number of people who will be offering for a particular assignment based on their location, their expertise, their class of contract, this thing, etc. And then there will be a shortlisted number of people who will be referred to the particular client, and then there will have to be an actual negotiation between the shortlisted clients and the shortlisted consultants and the client, which will be a supervised meeting where the registrar will be present. And after that, the consultants will send their financial proposals to FDPPA, which will be shared with the client, and ultimately the client will decide whom to take. Once he decides on the consultant, we will arrange a contract to be signed between those two, and our facilitation work will end for that period. Now, beyond this, if a client wants this backup support kind of a thing, that will be a different contract, which the appropriate consultants through FDPC will sign with this client, and provide that if for any reason this there's a problem, perhaps we will be coming back. Obviously, there will be issues of price commitment already made, and whether that will have to be done at the same price, or whether if the scoping has changed, if some revisions can be done. These are all practical issues which we need to work on. We will try to do that. But to make things a little more committed, we would expect the shortlisted persons, consultants, before going into a negotiation, to provide a small EMD kind of security deposit, which will be returned if they don't get the assignment. Maybe there will be a small handling charge which we would like to take out of that. Then the person who will get selected, of course, he will continue with the business. Same way, we will also expect the consultant to have a deposit of an EMD, which will be escrowed with the FDPC, so that at least there will be some cushion in case of defaults by either of the parties. We don't know how people will react. Of course, I am sure that the initial reaction from most of the people is, why I should do this? I will not do this kind of a thing. But we will see that over a period of time, this will get accepted. I remember that when I first introduced the concept of online e-court system, and we went to even Supreme Court at one point of time, way back in 2005, 2008, I think we went to Supreme Court committee around 2008 or so through another major certifying authority. At that time, whenever I suggested that we will have an online platform where judges will be there on the one side, arbitrators, not even e-courts, arbitrators will be there, and we will record the proceedings, it was looked at with horror. Judges said, nobody should view what I am talking in the court. It is confidential, something like that. But today we are having Supreme Court actually streaming the proceedings on YouTube itself. So there will be change. So likewise, I'm sure many of the people, even amongst you, who are having your own skepticism on how this will all work. So far, nobody has done this. So far, nobody in the world has done this kind of a thing. I would like to remind that the concept which we are trying to do here is not individually alien, in the sense that we have the arbitration councils which work on this kind of empanelment of experts, then getting an offer and then distributing it to the empaneled people on some kind of a criteria. And same thing we will be doing here for this kind of a contract. There is a system of classification of contractors in the government e-tendering system. So there are things which, and this aggregation of service is a very common thing which is happening everywhere. Every physical service today, we look at technology intervention through aggregation. So these concepts individually are established, and I'm not proposing something which is not known to the world. But in this consultancy area, data protection consultancy area, perhaps this has not been used, and probably that will be new. But I think we should be ready for such changes, just as Supreme Court has started streaming and accepted the exposure to the whole world about the proceedings happening within the court, where we are today in a position to judge the judge, okay, or judge a counsel for their performance. Similarly, here also, I feel over a period of time, it will get accepted. And the point is whether we are ready today to go for this new thought process. Now, as far as the inquiry is concerned, as I told you, the registrar will act as a mediator between the company which seeks the service, and then ensure that a matching consultant is found. And through the CMD system, we will try to secure the process to some extent, but otherwise we'll ensure there's a direct consultancy contract between the consultant and the client. And legally, as I told, we will be only be a facilitator and intermediary. And this platform itself will be run like a technology service, and it will be perhaps a new startup kind of an activity. That is why Ujjwala Consultants is supporting that. We already have a platform pilot in the arbitration kind of a thing. I have been putting something called ODR Global for a long time, without, of course, proper adoption in the marketplace, but the concept is there. And the same thing we will expand, and manually it can be done at this point of time with a limited number of consultants and other things. And as it grows, we will try to develop this technology platform. And when at that time, this distribution of inquiries to consultants, getting their consents, etc., may become automated. And the idea is that today, if I, as an individual, is negotiating with a prospective client, if I take, say, 2 days, 3 days to finalize, within the similar time period, this whole system also has to work. I am confident that it can work. I hope the other consultants also will look at the possibility. And this is the business model, which is unique, but could raise many questions. Most of you may have your questions now. That is why I would like to actually go in for this discussion. We have built, we have just introduced the website called fdpc.in. We have posted a consultancy registry empanelment form. We have also put the inquiry form for companies. So it is ready to be used today. Maybe once we have already a set of people who have tried to empanel them. We will perhaps be looking at how to bring them on board and publicize that, or maybe initially we will wait for inquiries to come and then publish. Right now, we are not taking any financial commitment from these people. we will have to decide whether we should take a registration kind of a commitment, or at least for the next 3 months, let us say, we will go for this no registration fee for these consultants. But when it comes to the shortlisted people having the discussions, then we will introduce this security deposit, which is a refundable security deposit like an EMD. Going forward, we may introduce a registration fees also, and all the members of FDPPA who have already paid money to become members, obviously they will get a free entrance to this new forum. Rest of the people may get this free entrance for the next 3 months, and then later on the management of this will decide. We are trying to build a small expert committee which can manage this, but as is a practice in all arbitrations and other things, there will be a designated person called the registrar, who will be like this chief operating officer of this platform, and he will be the ultimate, you can say, operational head for this. Everybody else will actually provide their guidance to this kind of a registrar. Registrar can be at present, of course, when nobody is there, of course, I will have to substitute as a registrar, but sooner or later, we may have a appointed person who will take that responsibility, so that this becomes a completely professional setup, like a startup. I have also invited some partners for this startup. I hope one or two of the people will respond, and then we will be ready to take it into a much higher orbit. So friends, this is what I wanted to discuss. Now is the time for you to raise your queries. I will try to answer as many as possible. Okay. Yeah. Now, I have one or two perhaps questions in the chat box. I will try to address it. One, Vaidi Chandramouli asks, for the same customer, there will be competition within FDC consultants. See, that cannot be avoided. Well, that's why I'm saying that we will broadcast it. Let people provide their interest. And ultimately, the user, which is the company which is seeking the service, he also has to get the best offer. So probably he also wants to have some alternatives. He doesn't want Naavi to designate A, B, C as the person who will take this thing. Then this will not be different from my own consultancy organization. It is not envisaged like that. So there will be competition, and whether there will be 3% shortlisted, 5% shortlisted, I don't know. It all depends upon the responses which we get when an inquiry is broadcast. But we may try to ensure that the locational preference and expertise preference are taken into consideration, in the sense that if there is a client in Bangalore, there is, of course, the Bangalore consultant of equal capability will get a higher weightage compared to somebody else who is in Bombay or somewhere else. So at that time, people should not feel that, okay, now he's in Bangalore, he's recommending only Bangalore people. That is something which you should have trust in the system which we are going to develop. And probably the committee which we will form for that will have to regulate any mismanagement in that. And until there may be a system of weightages and automatic selection, like in the case of Uber, who is the nearest driver, he will be called. And if he is an Uber Go driver or a higher end driver, based on your choice, that person will get the preference. Now, he will get the first option to refuse, and then it will go to others. Something like that. That is happening automatically there because they have built it up like that. Now, initially, we will be perhaps working on a manual mode, but trying to reduce bias to the extent possible based on the trust. And then we will try to upgrade this platform into an automated system where we'll give weightages, and based on that weightages, maybe shortlisting may happen on its own. Then this competition will be resolved in the appropriate way. I am now trying to say that it is not only FDC that is FDPPI certified people. There may be a person from some other forum who may actually bid for a consultancy. If the client is happy with him because he is a consultant who has got a DSCA certification or a CIPP certification, though he is not having an FDPPA certification, we have no choice in that. It is the customer's choice. But it is our endeavor, of course, FDPPA's endeavor to ensure that FDPPA consultants will always try to be better prepared than others. And if it happens, today's non-FDPPA consultant will perhaps take up the FDPPA examinations and then equip himself. That is the benefit which FDPPA certification division will perhaps get out of this. But we will try to avoid our bias to the extent possible. We will give the credentials to the client and let the client shortlist, and then there will be this negotiation. After the negotiation, the best person will win. That's all I can say now. Now, Atul Gaikwad, we can have two bifurcations, one for new consultants or one who are new to data protection and experienced small projects. That's what I'm telling when I'm saying I'm trying to classify them as class 1, class 2, class 3. The newcomers will actually start with class 1, and the established clients may directly be placed under class 3 or class 2, depending upon their requirements. So that is something which we are trying to take care. I hope my audio is okay. Now, Nitin, okay, whatever details you ask, I will try to provide it on the email. Okay. How does this model work? This is Ashok. If FDC consultant gets a requirement and needs a consultant with appropriate skill sets, then perhaps he will be posting his inquiry as a person who already has a contract, but he needs an assistance. So I think it can still work like that. It is only like a agent of the final user who is coming in. The same system can work here also, I suppose. Okay, Ashok? Yeah. Anybody else who wants to raise a question, you can unmute and ask also. I hope after the cyclone, my networks also have a certain problem. I hope some of you may also have a similar problem. Okay. Yeah. Any other questions? Mr. Lemay, you have anything? You are fully aware of the way arbitration councils work. I am trying to bring in a similar model here. And Anil, as a consultant, let me have your views. And some of you who are not associated with FDPPA, you are welcome to provide your views. Mr. Gaurav Mehta, Rajesh.
Sir, thank you so much for such an enlightening session. Just want to give a brief introduction and try to understand better how can we be part of this initiative. So we are basically a bunch of technology entrepreneurs who have been doing work with the forensic, like all the government agency, ED, SFI, and all those things.
Yeah.
Able to design certain would include the nomination method that you talked about, the automated deemed consent. How can a potential company can prove that the customer has taken conscious decision to provide a permission and all those things. So based on the technologies, right now we are tailoring our product and trying to do beta testing with a set of experts. Now, when I look at your current initiative, where the largest set of potential clients, as well as get our understanding better in the domain which we as a technologists have jumped into. So if you can pinpoint, then that would be really helpful.
Okay, definitely. Some of you may require further interaction directly with me. You are welcome. We will do that. Okay. Yeah.
Thank you, sir.
Okay. And those who are into technology can also let me know how you can help in building this technology platform. That is a opportunity which you should consider. Okay. Yeah. Samir, you are there only for a part time. Your views are very, very valuable to us. You need to actually put your thoughts into it separately and then let me know. Prakash. See, I want
No question.
all of you to help me make this possible. Don't look at it as a proposal which Naavi is giving, whether we should accept or not. Tell me how do we work together and make it possible? Yeah. Somebody wanted to talk. Okay. Sriraman. Yeah. I intervened. Somebody was talking. I intervened. I'm sorry.
Uh, Good morning, sir. I think this is idea is wonderful of providing platform, and it needs to be spread because now when data protection will be a reality, then this sort of platforms will help people to bargain better and get best out of the industry. So that is the best appeal we can do to whoever we know to join this particular forum. That's right now what I am looking.
Good. Thank you. Subraido has got something to say.
Sir, this is Gaurav Mehta again. I would like to
Yeah, Gaurav, tell me, Gaurav.
sir, based on the understanding so far, I think there is certain value addition that we would be able to do here. So first part, there would be a huge demand for the auditors or consultant or whatever be the new skills that is emerging because of the specific law, I would say. So therein, we as an subject, I mean, technology expert, we can help you build what we call edtech offering. So we have a certain open source offering from MIT and edX called edX. So we would be able to help you deploy those and get your top-notch online education academy live, wherein you as in subject matter expert, you can start creating course, curating course, and all those things. That's part one. Part two, based on whosoever has completed those courses, registration courses, there is an inbuilt what we call examination module that can help you create verifiable credentials. Call it a certification that are tamper proof and all. So that is the second thing. And obviously, once they have done that, you will be taking them as an input into your registrar platform or what we call the marketplace platform. So I think not much valued on third part, not an expert, but first two parts you'll be able to help.
Definitely, we'll consider. Presently, we are actually using outsourced agency only for such purposes. We have the courses which are being hosted on a platform. If you look at cyberlawcollege.in, that is hosted on a external service provider, and we are providing the online courses through that. And we have an examination module, online examination module also. That is how we have more than 200 people have been certified so far in different certifications. Of course, if they have been not integrated, I have been picking up the service as and when from different people. So probably there is an opportunity available there. And now what we are talking of is something like a CRM platform, which we are looking at, where we have to broadcast requests and get inquiries, kind of a thing. There may be a ready-made platform, or we may try to work out something. So all these technology elements will have to be tied up together. And that is why I said that this could be a startup. Today, I'm not looking at it as a big investment, this thing, and I'm looking at it as what we can run up to a particular level. Let us say up to about 50 to 100 consultants. I think we can run through a manually controlled mode. In fact, in the arbitration, ODR platform had a whole scheme for operating at even very higher level by having something like a workstation approach. So here also I can work out a workstation approach and have multiple registrars to take care of groups of say transactions, and thereby we can handle a large part manually. But in order to avoid bias, which may automatically creep in, and I myself may become unable to track all the happenings, and somewhere at the subordinate level, biases can come in. We would like to go for some automated mode, like say why we have got DTS, that is because we want an objective evaluation. Likewise, here also, we may have a criteria that even the shortlisting will have to be done on some objective criteria. Then even if I want 3, I can ask the technology to give me 10 recommendations and then have the manual committee look at the 10 recommendations. And we'll have that hybrid way of working with technology. So technology will definitely be helpful in all these things, not only in the EdTech area, but in the inquiry, receipt and processing area. And tomorrow, see, during COVID, we did a lot of interactions online, and some of this consultancy, at least certain stages, can happen, continue to happen online, which means that there will be a video interaction also as a part of the tools associated with this. So there are multiple technology elements I am looking at, which can, and of course, there will be certain technology tools which can be provided as a service. So now each consultant may not require to get the kind of license which may be required. Maybe we can provide some kind of a shared service wherever it is possible. So that way, this platform can provide, like I'm giving again example, okay, if I'm a Uber operator, Uber can have its own car mechanic service so that all the Uber people can get it repaired there, kind of a thing. Here also I can provide a set of tools for data discovery, or for say consent management, or for pseudonymization, kind of a thing, and say that we are going to make this available to the consultants at a particular price. So therefore, the value addition to the consultants itself can come, one, through the marketing support, second, through the technology tools, which each one of them may not be able to separately take. For example, you take forensics, every person cannot have a mobile forensic device, but if there are 10 clients here, they can always borrow that tool from me, kind of a thing. So similar things, technology support can be given. There could be continuing training support which can be given to these people. And those are the value additions which the platform can bring in. How it will work out in terms of costs and revenue and other things, so these are matters of business details which has to be worked out. But all these are presently the possibilities if we can come together. See, I was talking to Mr. Ramesh today morning that say 40-50 years back, when the chartered accountants came together to form an association, perhaps there were a few individuals who came together and said, we are professionals in a particular area, let us form an association. Today it has become an ICAI. Look at the range of services ICAI gives to the chartered accountant community, from examination, certification, dealing with the government, kind of a thing. I am actually thinking that this FDPC should grow into such an organization, which is a platform which the government should tomorrow ask. If they want to make a change in the data protection law, they should ask the consultants to provide their inputs. And when they come up with a new regulation, obviously we will give our input. So that is what I'm calling as the voice of the industry. So FDPC should become the voice of the industry. That will come from the numbers. That is how many people actually get into it and the quality of people who will get into it. Not all of them may actually look for business out of this. They may be big businessmen themselves. In fact, they can be actually sponsors and supporters of this thing, rather than expecting some small business to come from this platform. But lot of youngsters who are getting into the business would have the skills, but they are not in a position to market themselves, and they will perhaps appreciate some help. So different people will have different kinds of benefits which may come out of it. We will try to have this as a common platform on which all these people can work. We have a lot of experience in this, not only in FDPPI, my own experience over the last 20 plus years. I have worked as a consultant. I have got the services of other consultants as my co-consultants, kind of a thing, on project basis. I have myself worked as a co-consultant. So all these experiences, if we combine together into the business idea, I think we will be having an acceptable business model. That's what I'm trying to think. Yeah. Ashok? Anirban? Yeah. So have we completed the basic discussions? Fine. If there are no more
Yes, sir, I
questions,
think
yeah,
almost
tell me. Until Ramesh closes,
you have
I will
covered
not
almost
consider it as
everything.
closed. Yeah, yeah. Please go ahead.
Naavi sir,
So Rajesh,
Yeah, tell me,
so how are
Rajesh.
we planning?
Yeah,
How are we
Rajesh.
planning this forward, sir? I mean, we need to have a calculated
How?
approach. See, there are different things. While we set the forum, we should also have a library which probably the consultants can utilize while providing services. Like today, we have our own standard, but we also have international standards. We have different laws. Now, aligning to those laws required to do certain mappings, which can give that kind of comfort where the people would like to approach us to take that particular support. So when we look at Indian law, it is still yet to grow. I mean, because with many things as consent and deemed consent, so it will totally depend on the context of the purpose of such processing for which what data is collected, and that could differ from organization to organization. Now, so there is a quite wide ambiguity that this particular legislation, not only from Indian law, but even after 4.5 years of GDPR, you still have a lot of things we learn it new.
See,
So, do we have that pooled resource? Do we have
okay.
those capabilities to, yeah?
See, uh, because we are talking of a techno-legal compliance, this interpretations of the legal aspects will always be a challenge. No two lawyers will agree. Of course, final word is with the supervisory authority who says this is what I think is correct. So same way, judge when he says it becomes a final resolution, but not necessarily one which is necessarily correct or something like that. But so that cannot be avoided. But what we can do is to provide the support. As you said, having a library and other things is one of the things which are suggested, which is a good idea, which will be part of the training initiatives. Maybe even FDPPI can do that. And this platform can focus more and more on the technology aspects. And if somebody wants to be a training partner, he can conduct the training through this platform, but training will be separately done, kind of a thing. So we will work out those details. And there will be a battery of data protection law experts in this thing, like the forum which we have in FDPPI. So some of the say consultancy related to interpretations can be given. Even that can be posted here. If some organization wants to have a consultancy on certain interpretation and they want somebody to help them, that also is a consultancy. Like that there are people who are giving hourly based consultancy to on the online platform. So that was not my main focus here, but if there is an occasional request, that also becomes a pre-implementation consultancy discussion, which can also be priced. Somebody may say that I have a 1 hour discussion with you, provided this is my price, and if the company wants to take it, let them take it. Okay, so that will sort out the interpretation kind of a things. Okay. Then Gaurav Mehta is
So not
asking.
only consultants,
Yeah, I will come to
I'm
Gaurav
also
Mehta later. Yeah,
talking about the.
go ahead.
I'm also talking about the arbitration forums, because when you say it seems the data protection board has the power to decide who this board
See,
can
no, no,
act as
wait,
a,
I will
you know,
explain that.
we have to look at it. We have to look at it
No, agreed.
end to end.
See, wherever law provides an adjudication, arbitration, followed by a judicial authority like High Court, any arbitration cannot be a binding arbitration. It can be only a with recourse arbitration. That is why I'm saying mostly the mediation is what is feasible. Okay. In both ITA 2000, where there is an adjudicator, appellate tribunal, and then to High Court, here also it will be an adjudication at the DPB level, then an appellate tribunal. There is no appellate tribunal here. It may go directly to the High Court kind of a thing, or there may be an intervening appellate tribunal also if it comes. And in intermediaries, there is a grievance appellate tribunal, which may also be given responsibility here. I don't know. Now, wherever such a system is there in law, you cannot have an arbitration and say that arbitration is final, because law will not accept that. So that is the situation which we are now in. So I'm not looking at binding arbitrations, but it is possible that a non-binding arbitration can still be done. Both the parties agree that, okay, this is an attempt one step higher than mediation. Mediator actually does not try to solve the problem legally. He tries to only resolve the issues to the mutual acceptance. Whereas an arbitrator is a legal person who tries to decide on an issue based on the legal questions involved. And even after that, the parties may agree that we will go through a with recourse arbitration, but either party may tomorrow disagree and go to a next level. But normally such arbitrations are not preferred because people will not put in their evidences fully in the kind of arbitration. So that's why I'm banking more on mediation, negotiation and mediation. And then perhaps it will go. This is even before you go to the adjudicator of the DPB, which means that companies which are required to place grievance redressal mechanisms, I am saying that please use our DD map system. We are ready, and there are a few people from our own people. There can be an Limaye, there can be a Ruchika, somebody, not necessarily perhaps a Kapil Sibal or somebody. If Kapil Sibal wants to come and argue here, we are welcome, because this is only a platform. And any person, you can bring in any known lawyer. Otherwise, we have our own people. That can happen in terms of mediation immediately. And after that mediation, which happens within the grievance redressal system, this does not require any legal permissions from government and other things. If X company wants to use the services of ODR Global or DD Map for mediation, it can incorporate that into its contract and then go ahead and do it. Mediation ultimately ends up either with the parties agreeing and signing. If they don't agree, mediation fails. So there is nothing unrealistic about it. And then you can go to the adjudicator. You can consider this as an intermediary step that can happen. Okay. This arbitration is being avoided because there has been questions raised in other forums that where the law provides for some proper method of grievance redressal, there cannot be any binding this thing, and you cannot say that since arbitration is over, you cannot go to the adjudicator, you cannot go to the High Court, you cannot say that. So that's the limitation with which we have to work. Okay. Now, Gaurav Mehta is asking a question, how are we different from NASSCOM DSCI initiative? I don't know what is the NASSCOM initiative, what is the DSCI initiative, which is similar to what I am proposing. If Gaurav has any idea, he can tell me. If anybody else thinks that there is some similar initiatives, you can tell me. We will try to understand that and make things better. But I am now trying to say that DSCI consultants can come in and join this FDPC forum and provide their consultancy. I'm not going to insist that they should undergo the FDPPI certification only. That is the difference between our earlier approach and this. This is a broader approach. Yeah, Gaurav Mehta, you've got anything specific, any particular project which you want to say, refer?
So I think he's not there.
Okay. Okay.
I think Gaurav is not around. He raised a question in chat, sir, that how it is different to DSCI, Data Security Council of
Yeah, tell me, is there any such
according
initiative?
To get the answer.
Is there any such initiative? I
Yeah,
don't think so.
I think it is.
Tell me.
No, I want to add here, sir, that DSCI takes a lot of initiative, definitely at an industry level. But the major thing which the industry needs right now, which I am pitching for last couple of weeks, sir, that they need on-job support. Industry needs on-job support. Okay, and if someone appoints a DPO or someone appoints a data privacy manager, there is no one in the organization that is support on job the person, because the person is the only knowledgeable person in that industry regarding data privacy. So that's where FDPPI plays a huge role, where we do have the forum, or we do have the capacity, or we do have the members, volunteers, definitely volunteers is the right words to use here, to support each other and get each other's back. So I think that's where we play a major role or differentiation between DSCI or any other respective authority and FDPPI, that you get that support, you get that platform where you can and definitely have the answered in real time, or have the debate, or have the brainstorming session. Yeah, that's what I want to add from my side for an answer of the question.
Okay.
Sir, Naavi sir, Sameer here.
Yeah, please go ahead.
So answering Gaurav's question, although he's not there anymore right now. So I think there are very less, similarities between FDPI, FDPC, and DSC on the other hand. DSCI is more of data security council, and they are doing a lot of work on data protection, where we are focused on privacy. Secondly, with the backing of NASSCOM, I don't think there is any comparison between the two organizations. There might be 10-20% overlap, which is quite fine. But I don't think that's an area of concern for this group, that we are kind of overlapping with any initiative of DSCI. DSCI is, of course, into privacy, but overall, if you see if they are putting in 100 hours every month on various activities, the activities on privacy will be below 5%. Most of it is around data security, which is all right. So that's one thing I wanted to say. Other thing I wanted to add was that you mentioned my name, but I was in some other call. So the question I have for this FDPC proposed forum is that before we get into this, we must do a market study of what exactly is the potential business that is currently happening for potential proposed FDPC consultants. Ramesh sir, you are there? Ramesh Venkatraman sir?
Very much. I'm listening. I'm here.
So if you remember, we discussed this briefly last week.
Yeah.
And we had discussed this point of how big the business is, and out of that part, how much should we look at converting into FDPC. So unless we have some kind of figures, which I don't have right now, because Naavi sir mentioned in his talk today also, and in the note that he had put up on email and on the group about SMEs. Once the law, bill turns into law, then SMEs going after it. So I don't see that happening, sir. SMEs, like I have always been saying, are not going to be starting on this for the next 2-3 years. But yes, large enterprises are going to, obviously, because of compliance issues, they will have to get into compliance from a privacy point of view, and then consultants requirement will be there. So that's the second point. Third point is that I'm not very clear on FDPC or FDPI charging a fee, whether it is 10,000 rupees or 10%, 5% from the client. So client, unless FDPI takes the responsibility or the ownership of delivering the final deliverables, customer will not pay consultant separately and FDPI or FDPC separately. Those 3 points I wanted to raise.
No, what I mentioned was like an earnest money deposit, which is like the advance which we collect as a consultant before I start an assignment. Say normally when we take an assignment after the conclusion of the negotiation, before we start, every consultant would like to have some advance payment. Okay, like that I'm trying to say, and that will also be escrowed with the organization. It will not be paid to the consultant straight away. This is the practice. In the case of arbitration councils, the entire fees is collected in advance and kept escrowed and will be handed over to the consultant only at the end of the assignment. So that I'm trying to say 10% of the contract value can be put as an EMD with the organization, not the fees. Okay, fees will separately decide.
My point is that if the customer has paid FDPC a 10% fee or 10,000 fee, whatever, then it becomes FDPC's responsibility to execute the project.
No, I'm saying FDPPI or the FDPC will be only a facilitator until the contract is completed. And for that, whatever handling charges and other things we have to identify, we will try to decide on that structure. But subsequently, it becomes a consultancy contract between the consultant and the party. We may even try to develop a standard contract for that purpose, or we will ask the consultant to work on that format himself. Okay. Samir, you are offline for some time.
No, I'm back, sir.
Okay. So I was telling that this what you referred to as the payment from the client side, I was intending it to be only like the advance payment which consultants receive, or like an EMD kind of a thing, okay, which is held in trust, so that suppose the client also tomorrow backs off, then the consultant may say, I've spent so many hours, you are not giving me any reward, no, so I have to use that EMD amount for as a forfeiture and then apply it. If for the client,
I am not convinced on this EMD part. No private company will give EMD to either FDPC or any customer.
No,
advance is separate.
No, will they not give you advance? If you take a consultancy contract, will you not ask for advance before you start?
That advance, whoever asks for advance, then the ownership of the delivery lies with them. We cannot say that we will
Okay,
take
I
advance.
understand that. I understand that. But here I'm saying that you would have given the advance directly to the consultant. I am asking that advance to be escrowed with us, which is safer for you also. It is safer for the customer. The consultant may say, if I had directly done it, I would have got the advance myself, which you are holding. Whether you can release a part of that or something like that, stage wise, perhaps we may try to release something like that. But this is something which you think over it. If we open it out, there is possibility of more disputes arising out of non-fulfillment of the financial part of the contract. So at this point of time, I have felt it is necessary. Okay.
So Subramanian here,
Yeah.
one question.
Yeah.
I think the framework and approach is all very good. It's quite exciting. It's somewhere, see, we have a data protection standard, PDPSI, I think now it's being given different name or something. Will FTPP also publish some kind of standards for reports and formats of reports or something? Because what happens is that ISO has got some report formats, SOC, for example, I do ACP SOC certification, they've got their own report formats, a qualified report, unqualified report. So these things gradually, from just being a facilitator to, also publishing certain standards that FDPP expects its consultants to adhere to. Because ultimately what Samir sir also asked, that earnest money deposit, whether to be returned or not, when, what part, all these revolves around whether the consultant has delivered as agreed with the end customer and in accordance with FDPP standard, something will come up. So somewhere standards on under what condition should an adverse report be given, what should an adverse report look like, these issues may crop up.
See, out of the consultants, there will be one set who will be FDPPI certified consultants who will adhere to this framework, which we can call as PDPSI. But as of now, I am not trying to make it mandatory, because if I make it mandatory, then somebody will say, I will have 27701 framework. Why should I consider PDPSI better than 27701? We will separately, privately address that. But I don't want that to be a stumbling block. If there is a consultant who wants to adopt 27701, and if there is a client who wants only 27701, I am trying to leave it to their choice. But at every point of time, our framework will be there. We are going to say our framework incorporates the best practices of 27701. And therefore, if you are going to PDPSI, you are not sacrificing anything. That concept is already there. But I am now trying to actually free the mandatory nature of that. So far in FDPPI consultants, we were only looking at those who can certify on the basis of FDPPI framework. Now I'm trying to say that there may be a better acceptability of this platform if you consider this only as a technology platform, not an FDPPI consultancy service. Okay. Then if you take it as an FDPPI consultancy service, then the nature of the transaction differs. Now I am trying to make this only an intermediary and leave the...
Yeah, so I think what you're saying is FDPPI or this FDPC will only be a kind of matchmaker, nothing more than that.
Yes, FDPPI actually will be maintaining an arm's length relationship, and it will say that this is only my affiliated body kind of a thing. Okay. Whereas the organization which manages this, it will have the platform kind of a thing, responsibility as a technology service provider and an intermediary, and it will facilitate up to the point of contract. That is what I'm saying, that I am trying to go back to that Uber example and say Uber should have considered itself not as a taxi operator, only as an aggregator of information. And once the contract is finalized and a taxi is assigned, they should walk out of the contract. That did not happen. That is a different thing. Now I am trying to say that that is the kind of relationship I would like to build, because that is safer for the platform as well as for FDPPI. Okay. So, Subraidu, that is PDPSI will continue to be promoted by FDPPI, and if people accept that as a better framework, in fact, that will be part of all our certification system. And I'm sure that we will try to make it look and feel better than other platforms. And hopefully, sooner or later, that will have a major market share. Then that's why I'm saying even people who are today not in FDPPI will come to FDPPI certification trainings, learn about this PDPSI, and they will join that select band of people. So if the client asks, see, I don't want to say to the client that you should take only FDPPI certified persons, then it becomes a bias.
Yeah, correct.
I am saying that you have got this FDPPI certified persons and you have got others. If you want to know more about what is the difference, that knowledge we will give. But beyond that, it is your decision. If you think that an FDPPI certified person using the PDPSI framework is better suited for you, take him. Now, tomorrow, if see Data Protection Board comes in, we present the PDPSI framework to them and they give some kind of a blessing to that. Maybe that is one reason why clients will look at that as one of the choices. So I want to leave it there rather than telling the client that we prefer you using our own FDPPI certified persons, because then that will open up another Pandora of objections, which I'm trying to avoid.
Yeah, because this is also following up with the 10% TMD or whatever, because somewhere what he's saying is there can be a situation where, let us say, the client who has taken a consultant through FDPC comes to FDPC and say, hey, I didn't like this guy, he didn't like this, he didn't do this good job or something. Under such conditions, there might be a
I'm
situation
saying
where
I'm giving him an option for an alternative, what I call as a backup support contractor. Okay, it is like in many times when you are having a technology tool, you supply the technology tool to the particular user and then tell him that you have to manage it. But if you want me to manage it, then you have to give me another AMC contract. Likewise, here the contract will be bifurcated into two. One contract will terminate once we facilitate the choice of this thing. Then if that client says, I understand you also have this backup facility, will you give this? I may charge some fee for them. And in that fee, I am going to share a sort of an underwriting commission to the few people who are willing to say that your primary contract, you don't give it to me, let your people handle it. But if any of your primary contract persons fail and suddenly some help is required, I will come in. So there they will have to look at the probability of primary contractors failing. So if they feel that if I get 1% on all the contracts and only 1 in 20 or 30 contracts I have to actually pitch in, then they may think that underwriting is a profitable business. Okay, so I am trying to look at it like that.
yeah, okay. A couple of things I think they may get smoothened out as we move along. Particularly when you're talking about this, replacing the client saying I'm not happy and FDPC saying okay, I'll replace this with Y, then there's where potential loopholes or stuff would come up. The consultant could say no, FDPC.
So that is why dispute resolution also becomes part of this. Once a dispute arises, we have to have a grievance redressal system. There we will decide who was at fault. The client, I mean, the consultant may say I was not at fault also, no?
Yeah,
so
correct.
Somewhere
and he might resist FDPC and he might say that no, I don't want you to appoint any other alternative guy or something because I was right.
Yeah. So at that time we have to settle him with some payment or something like that. With the client has to take the responsibility for that. If in that negotiation, if it becomes necessary, client may say I don't want him anyway. So, but if he has already put in some efforts and that has to be compensated, I will pay that off and then look at the other consultant. That is again similar to the current situation where you may have such situations even when you directly appoint a consultant. Okay, here the only difference is this consultant is coming with some kind of a recommendation from FDPC. So to that extent, there is a moral obligation for us to only recommend the right kind of people. Otherwise, we will have to blacklist them. If without reason, if a consultant is backing out, he will get blacklisted. And if this service succeeds, people would like to avoid that blacklisting in a way. And even if they want to walk out, they may walk out without any payment. So that way, the project may get delayed, but beyond that, there may not be a financial loss to the customer. So something like that we have to work out.
Yeah, these things will get sorted out as we move on. But yeah, in concept, it's basically a marketplace for consultants on data protection is what.
Yeah, see, these are all challenges which has already been faced in the consultancy market, in a construction consultancy and other things. Only thing is we have to import those experiences. It is a massive business anyway. It's a massive challenge also. That's why we may start small, but we may be ready to take it to a higher level.
Yeah. Okay. Thanks.